So, did you know that over the last several years here in the United States, there was this very carefully orchestrated plan that was being carried out to introduce the first ever fully taxpayer funded Catholic public school? And would you also be interested to know that the individuals and entities affiliated with this project, behind this project for this taxpayer funded Catholic public school, happen to be the same individuals and entities that I've talked about, including Leonard Leo and Opus Dei? I am going to guess that unless you happen to be following this type of news, you probably completely missed this story because, spoiler alert, things did not end up going according to plan for these people and their Catholic public school. And I think that it's important for us to talk about what happened, why things did not end up working out, and where the trajectory of things may be headed now. Because I think that there has been an onslaught and attack on the church state separation here in this country. And I think that a lot of people, a lot of the American public, don't realize how critically important that church state separation is and what we would lose if it went away. And so I want to spend some time today talking about this case, talking about what happened, talking about some of the historical precedent for the church state separation, how the federal government has traditionally handled the church state separation, and again, how things are beginning to change now. So, hi, my name is Beck Griffin. You are watching the Deep Dive Project. I am an independent citizen journalist who has been talking about matters pertaining to human rights and public concern, specifically within high control religious organizations, more specifically within Catholic high control religious organizations. And through learning about these groups and organizations, I've also become aware of some things that are happening within my country's government, with governments around the world, and with society as well. And I feel like the work that I have done has opened my eyes, broadened my horizons, and helped me to identify what I care about, what I want to put my effort and my voice and my money behind, and how I want to move through the world. And that has all been facilitated by asking my own questions, doing my own research, and trying to engage my critical thinking skills, which has been an ever evolving work in process because I feel like I wasn't necessarily set up for the best success in that regard, because I was raised in a very conservative religious environment in the American Midwest. And so I have found this work to be very personally empowering, but also illuminating. And it's given me an opportunity to connect with people all over the world. So I am so incredibly thankful for the opportunity to be doing what I am doing and to be talking about these issues. Of course, this is all opinion based, and you are allowed to have your own opinions and you are allowed to disagree with me. But if you are nasty about it, I will clap back and I will not apologize. So you have been warned. I feel like I have to say that because I know that the topics that I discuss have a way of bringing in some interesting people from some far-flung corners of the internet. So if that is you watching this video now, you have been warned. I will not tolerate your shenanigans here on my channel. And also remember, I do not work for you. This is all independent, and I am sharing this work because my goal is to empower people the same way that I have been empowered to ask your own questions and to do your own research. I don't want to be the one-stop shop for anyone on any one subject. This is just me sharing my own research, which I would be doing anyway, regardless of whether or not I had a platform to share it on. But being able to share this stuff is a very, very gratifying and bolstering, because I think if I was having to absorb all of this information and I couldn't talk about it or share it with anyone, it would be really, really, really difficult. So thank you to everyone who has come along for the journey so far. You can learn more about my work up to this point and the different subjects that I have been discussing over on my channel, and I hope that you will stick around if you're not subscribed already. So with that said, let's go ahead and get into things today. We're going to be reading a series of articles, starting first and foremost with an article that I wrote. And I think that's going to be the best way for me to give you a broad but all-encompassing summary of this entire situation as it stands right now. So this is on my Substack, Bat Griffin and the Deep Dive Project. Please consider subscribing. You can subscribe for free, which is amazing. You can become a paid subscriber, which is incredible. Any type of support is very, very appreciated. And if you would like to, you can find a link for my Substack in the description of this video, along with a source document with all of these articles linked. Please feel free to go through and have a look at them at your leisure. So the headline of my article, Opus Dei tried to dismantle religious liberty in America. They failed this time. So I'll scroll past the first couple of paragraphs here. I wrote this article back in February, and so I was reflecting on some of the current events that were happening at that point in time in this country. Now it practically feels like ancient history because I feel like time is just going faster than we can hold on to it, and things just seem to be devolving as we speak. But anyway, I'll skip to the meat and potatoes here so that we don't get bogged down. There are some incredibly powerful and well-connected people who have worked very, very hard to ensure that there are allies sympathetic to conservative religion in places like the Supreme Court. Over the last several years, there has been a steadily advancing plan to erect a fully taxpayer-funded Catholic public school in America, which is part of a broader and much older effort to completely dismantle the separation of church and state in American governance. But in May of 2025, that plan was quietly halted in its tracks by the U.S. Supreme Court and sent scuttling back to Oklahoma to recoup. I had been following the progression of things since the Oklahoma AG sued the St. Isidore of Seville Catholic Virtual School back in 2023, sending the case, now referred to as Oklahoma Statewide Charter School Board v. Drummond, ping-ponging from the Oklahoma Supreme Court, who sided with Drummond, to the United States Supreme Court, which was, I believe, the plan all along. There are some incredibly powerful and well-connected people who have worked very, very hard to ensure that there are allies sympathetic to conservative religion in places like the Supreme Court. I think that they hoped that the time was right to bring a case like this forward. Now, that did not end up working out this go around, and we will get to the particulars in the moment. But first, I want to spend some time going over some of the background context because it's important. And I suppose that I should go ahead and state the obvious now. I already let the cat out of the bag. There are Opus Dei fingerprints all over and around this thing, which for me, with the research that I've done, the people that I've talked to, and the opinions that I hold, is hardly surprising. To most Americans, the concept of a Christian public school would probably strike a discordant tone with the general belief that there should be a clear, unmistakable delineation between acts of the state and acts of a church or a religious organization. And while legally speaking, there has been quite a bit of discourse over the finer points of this separation, the Supreme Court had historically relied on the Lemon test, which is from a 1971 court case, Lemon v. Kurtzman, which we will discuss in a moment, and which were a set of 3 criteria that government policy involving religious institutions or activities were required to meet in order to be valid. And these 3 criteria were as follows: must have a secular legislative purpose, the effect must be neither to advance nor inhibit any religion, and it must not foster an excessive entanglement with religion. But in 2022, the U.S. Supreme Court completely abandoned Lemon, ruling that courts must instead rely on historical practices and understandings. And I guess Lemon wasn't historical enough. From where I'm sitting, this reads like one of 1,000 tiny cuts that are slowly but surely chipping away at the separation of church and state. And considering the fact that just a few months later in 2023, movement towards opening St. Isidore's began in earnest, it's hard for me not to feel like the movers and shakers behind the whole affair were paying attention when the U.S. Supreme Court discarded Lemon. Before overturning Roe v. Wade, something like dismantling the church-state separation might have seemed like a fanatical pipe dream. But now it honestly just feels like the next logical step for these people. An exclusive published on Politico back in 2024 revealed that since successfully ending Roe, the same legal team behind much of those efforts, the Alliance Defending Freedom, had turned their sights on supporting the introduction of the nation's first taxpayer-funded religious charter school. The Alliance Defending Freedom allegedly benefits from the financial largesse that groups aligned with Leonard Leo dispense. And if you somehow missed it because you live under a rock, Leonard Leo is one of Opus Dei's most lauded and feted supporters and a man with no small part to play in shaping the political landscape smothering our governance today. I can't say if he is a member of the organization or not because Opus Dei won't say, and Leo has neither confirmed nor denied it as far as I know. But it hardly matters. The relationship is clearly real and well documented in the public record. St. Isidore's certainly is lucky to have such well-funded backing, but then again, this entire venture has hardly grown in a vacuum. In addition to the Alliance Defending Freedom, the Judicial Education Project, the Donors Trust, the Federalist Society, the Notre Dame Religious Liberty Initiative, at the University of Notre Dame, the Roman Catholic Archdiocese of Oklahoma, and the Becket Fund. All of these organizations are all entities connected to or directly organizing and supporting this Catholic school. And if you know anything about the conservative political landscape in America, these names are probably jumping out at you. And isn't this all starting to feel a lot less homegrown and wholesome? From my perspective, the fact that St. Isidore's is affiliated with some of the same entities and individuals directly responsible for the current political landscape in the U.S. Supreme Court, who were also directly responsible for overturning landmark legislation for women's rights, is far from accidental. St. Isidore's was the Trojan horse for a plan intended to subtly and I have a hard time with this word every time I read it, irrevocably alter the church-state relationship once and for all. The organizers thought that they had everything that they needed in place to ensure a landslide victory. But their plan had one tiny flaw that completely knocked their calculations off kilter. One of their shoe-in judges, Justice Amy Coney Barrett, was forced to recuse herself, and although no specific reason was given, it is a matter of public record that she was taught with and was friends with Notre Dame law professor Nicole Garnett, who was an advisor to the St. Isidore School project. Because of her recusal, something that they probably should have been aware of going in, considering how important networking is in Washington, the vote resulted in a 4-4 split decision, rendering St. Isidore's dead in the water. So it ended in a draw. This is a pretty big deal, considering what is at stake, and I can't help but feel that were it not for Barrett's apparently totally unknown conflict of interest, and I really would love to know who dropped the ball on that one, I would be writing and reading a very different kind of article. If things had turned out differently, I have no doubt that we would see a spate of articles crowing over the victory. Instead, there's been silence. The church-state separation remains intact. To fight another day, but it would be a mistake to let your guard down and assume they won't try again. In fact, they already have. A different Catholic academy, the St. Carlos Acutis Classical Academy, has apparently won the jackpot and now features the exact same governing board who sat on the now defunct St. Isidore's. Isn't that interesting? While St. Carlos Acutis isn't trying to do a repeat of St. Isidore's, it is positioned to take advantage of a tax credit that assists private school students with tuition and fees. Who knows what else they may have up their sleeves, but I have a hard time believing it's nothing. That's just not these people's style. And by people, I mean the Opus Dei brand of diehard Catholic fanatic with unbending loyalty to a mission of global re-Christianization. The kind of people who started to get their act together back when Reagan was still in office, who have ushered dozens of conservative political players into advantageous positions, and who are, as I read this, seeing the near total completion of a white paper that I was called a conspiracy theorist for pointing out was undemocratic and inhumane. I'm not going to say that I was right. I'm not going to say I told you so. But I'm sure that's going through a lot of people's heads right now. I will certainly be keeping an eye on this situation, and when it comes to the subject of Catholic schools more generally, I have more to say. But for now, I will leave things here. If there is one thing that I think we can always count on, it is the tireless efforts of fanatical ideologues to ram their beliefs and lifestyles down everyone's throats. I just hope that for every one of them, there is at least one person willing to push back and say no, even if that person has to be me. And luckily, I am not the only one, which is a very, very good feeling to have. Although, who knows if it's going to be enough at the end of it all. So anyway, this is the first article to kind of get us oriented, get us situated with what we're going to be discussing today. I wanted to lead with this because I didn't want to bury the lead too far. People complain that I take too long getting to the point. So this is the primary focal point of the rest of this video. And now I'm going to take you through some different articles, different web pages, talking about different aspects, either indirectly or directly pertaining to this entire church-state conversation. So the first article that we're going to look at is from historynet.com. It's just an article talking about the history of the separation of church and state in the U.S. And I wanted to read through this because, again, I am not sure how many Americans really have a working understanding of the church-state separation, why we have it, why it is important, why it is such an integral part of American liberty and freedom. So please stick with me as I read through all of this, or at least go through it in your own time and maybe try to have some conversations with the people in your life, see where their heads are at when it comes to this subject. So again, the history of the separation of church and state in the U.S. I'm just going to read through here and see what we can learn. It says, in June 2022, a divided U.S. Supreme Court handed down 2 decisions on how to balance the 2 freedom of religion provisions of the First Amendment. The justices took a dramatic turn from the history of judicial interpretations of those 2 provisions. Those 2 provisions read that the government, quote, shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, end quote. The problem arises when a policy meant to make clear that the government is giving no favor to any particular faith ends up being a barrier to citizens participating fully in their religion. A perfect example, Carson v. Macon, one of the 2022 decisions, where a 5-3 decision found that Maine had gone too far in avoiding the establishment problem by leaving parochial schools out of a tuition reimbursement scheme for parents who live in a school district too small for a public high school. While theoretically there is that tension between the 2 religious freedom clauses in the Bill of Rights, it was not until recent decades that balancing the 2 provisions had been controversial. When added to the Constitution in 1791, there was no recognition that there could be tension between the 2 prongs of religious freedom. Many of the founding fathers personally chafed at the way the Anglican Church, not their church, was entangled in the governmental affairs of Britain and wanted to be sure to be able to worship in their own way. And on a very practical level, they saw how diverse their new country already was, and by guaranteeing everyone the right to worship in his or her own way, they could avoid the serious religious conflict that had raged across Europe. Those views became central to the country's self-image. So the first 2 legal disputes involving the Establishment Clause did not reach the Supreme Court until the dawn of the 20th century. They both disputed federal aid to religious institutions, and in both of the objections were turned back by unanimous decisions. In Bradfield v. Roberts in 1899, the justices okayed federal money for constructing a Washington, D.C. Catholic hospital that agreed to care for the poor. And in Quick Bear v. Leop in 1908, they allowed the government money to go to the Catholic Indian Bureau to run mission schools for Native Americans because the money came not from general government revenue, but from a trust fund of money paid to the tribes as compensation for land they ceded to the U.S. And by ceded, they mean lost because it was stolen from them. The Bill of Rights applied only to the federal government, not states or cities. When the Constitution was adopted, some of the original states did have official or established religions, and the practice continued until 1883 when the last holdout, Massachusetts, dropped its official support of Congregationalism. It was not until 1947 that the justices again addressed head-on the extent to which the Establishment Clause forbade governmental involvement with religious institutions. It was then that they held that the religious liberty guarantees of the First Amendment applied to the states as well, that it was part of what it means when the 14th Amendment decrees that no state can deprive any person of liberty. That decision opened the way for future litigation over whether state and city programs directly or even indirectly helping a faith-based organization could be considered establishing a particular religion. The question of when government was favoring a particular religion that had been addressed with unanimity at the turn of the century was now a divisive issue, settled with a 5-4 vote. The case, Everson v. Board of Education, was brought by a disgruntled taxpayer in Ewing Township, New Jersey, who objected to tax money being spent on reimbursing families for the cost of their children taking public transportation back and forth to school. His complaint: the program covered both public and private school students, and since that helped support Catholic parochial schools, it was, in effect, aiding religion in violation of the Establishment Clause. The court okayed the transportation reimbursement scheme, noting that the money did not go to the parochial schools or support them in any way, but helped all parents regardless of their religion. But even in disagreeing on the permissibility of the transportation reimbursement scheme, all the justices agreed on the purpose of the Establishment Clause. Both the majority opinion and the dissent used the same phrase to describe the clause, saying that it created a wall of separation between church and state. Its application to public education policy continue to be at the heart of the Supreme Court's cases involving the Establishment Clause. In 1962, it called it unconstitutional for New York State to begin all school days with a set 22-word prayer, even though the prayer was carefully crafted to be non-denominational. The next year, it held unconstitutional the reading in public schools without comment of verses from the Bible, although the 8 justices in the majority went to some pains to explicitly state that they were not banning study of the Bible or of religion when presented objectively as part of a secular program of education. In 1968, the court, in a 6-3 decision, okayed a New York State policy of lending textbooks to school children. The majority said it was okay for the state to include students in parochial schools because the only textbooks covered by the program were in secular subjects, and that was Board of Education v. Allen. Now we come to the Lemon Test. Finally, in Lemon v. Kurtzman in 1971, the justices tried to end the piecemeal approach to deciding when ties between public education and religion breached the wall between church and state by handing down a general test to be used in such controversies. Chief Justice Earl Warren wrote that for a government policy involving religious institutions or activities to be valid, that is, not considered to breach the wall between church and state, it must meet 3 criteria. And we read these in the article. It must have a secular legislative purpose, its effect must be neither to advance nor inhibit any religion, and it must not foster an excessive entanglement with religion. A unanimous court applying that standard threw out a Pennsylvania scheme that used tax dollars to reimburse parochial schools for the cost of instruction, teacher salaries, and textbooks for the secular subjects in the curriculum. That, the justices found, involved far too much entanglement. Using those criteria, the justices later struck down New York's awarding of grants to maintain sectarian school facilities in Committee for Public Education v. Nyquist in 1973, and Ohio's providing parochial schools funds for school trips in Woolman v. Walter in 1977. But applying that same criteria, the justices found permissible Minnesota's tax deduction for tuition payments to private schools, whether secular or sectarian, in Mueller v. Allen in 1983. And the inclusion in Washington State's vocational rehabilitation program financial support for a blind student attending a Bible college in Witters v. Department of Social Services, 1986. So these were all court cases that were successfully ruled on using the requirements of the Lemon Test. While increasingly attacked by legal scholars and even some justices, the Lemon Test was, until very recently, still the standard for lower courts to use in assessing Establishment Clause litigation. 20 years ago, it provided the justices with the precedent they used in Santa Fe v. Doe in holding unconstitutional the policy of allowing student-led prayers at school football games, because the practice had a religious, not secular, purpose. As recently as 2005, litigants specifically asked the court to overturn Lemon, and the justices refused to do so. In 2019, Justice Brett Kavanaugh, writing for himself alone, insisted that, quote, the Lemon Test is not good law, end quote, and Justice Clarence Thomas said he would overrule the precedent. Finally, in 2022, they abandoned Lemon. In Kennedy v. Bremerton School District, by a 6-3 vote, the justices said the school district was wrong to fire a coach for ignoring orders not to lead midfield prayers after football games. Henceforth, they decreed the courts, in considering conflicts between the two religious freedom clauses of the First Amendment, should not use the Lemon Test, but historical practices and understandings, which, again, is an interesting turn of phrase to me, because apparently the Lemon Test was not historical enough, even though it had been successfully used in the past. So I wanted to read that because I think that gave a nice background context to this discussion of the history of the separation of church and state. Clearly, this is very broad, very basic overview. There are tons of awesome videos on YouTube. There are fantastic articles and books and podcasts and interviews and entertainment media as well that talk about the history of the separation of church and state, the battle between the separation of church and state here in this country. And I implore you to seek some of those out and educate yourself a little bit more on this subject, because I think it is just really, really important. This page here talks about Lemon v. Kurtzman, the 1971 case that gave us the Lemon Test. This is on Justia, and I'm going to read through just the primary holdings, the facts, opinions, and the commentary here. You can read the entire case on this page if you really want to, but I'm not going to be doing that today. So this case was argued March 3rd, 1971, and decided on June 28th, 1971. The primary holding, the test for determining whether a law meets the requirements of the Establishment Clause, is whether it has a legitimate secular purpose, does not have the primary effect of either advancing or inhibiting religion, and does not result in an excessive entanglement of government and religion. Under the Non-Public Elementary and Secondary Education Act, Pennsylvania gave the superintendent of public schools the authority to allocate state funds for textbooks, educational materials, and teacher salaries in private schools. Most of these private schools happened to be Catholic institutions. However, the law was carefully written to require that the salaries of teachers could be augmented only if they taught the same courses as those offered in public schools, used the same materials, and refrained from teaching courses in religion. In reality, the only beneficiaries of the extra funding were teachers at Catholic schools, which constituted 95% of the state's total private schools, which in turn comprised 25% of all elementary schools in the state. So not an insignificant percentage. In Rhode Island, a similar law known as the Salary Supplement Act designated government money to provide salary supplements of 15% for teachers at private schools. Most of these institutions were also Catholic. The First Circuit had ruled against the Rhode Island law under the First Amendment. Describing the prong of the Lemon Test that concerns excessive government entanglement with religion, Berger recommended that courts consider factors such as the nature of the government assistance, the character and purpose of the institution receiving the assistance, and the relationship that resulted between the government and the religious authority. All three of the prongs in the test, which are listed in the primary holdings above on this page, must be satisfied for a law to survive a challenge under the Establishment Clause. In this situation, Berger pointed out that private and parochial schools were essentially synonymous in the state, and that the Catholic Church viewed its educational program as a central part of its religious mission. Viewing the cumulative effect of the relationship between the state and the Catholic Church created by this law, he found that there were excessive entanglement between government and religion. Once he made this finding, the law would be unconstitutional whether or not it passed the other prongs of the test. So And in case commentary, it says the Supreme Court held that the founders clearly intended to prevent the state from any type of sponsorship, financial support, or involvement in religious activities which verged too closely on establishing a state religion. While the Lemon Test has been challenged early in the 21st century, at the point that this page was published, the court was continuing to use it as a principal tool of Establishment Clause analysis. So now it begs the question, since they have thrown the Lemon Test out, which seems like a shame to me because it seemed like a very handy, straightforward tool to use to test if there's an unconstitutional church-state entanglement of some sort. What are they going to use in its place? They said it had to be based on historical precedent and whatnot. And apparently this Lemon Test is not historical enough. So I'm not clear yet on what the Supreme Court will decide to use going forward. I'm also not sure if they have already come out with something saying what they will be using. I haven't seen anything. If you follow this type of law, if you're more familiar with law than I am, I'm not a lawyer, nor am I claiming to be. Feel free to chime in the comments below if you have some more context or know anything more about this, because again, they've thrown the Lemon Test out. The Lemon Test was the test for determining whether or not there was some sort of violation of the Establishment Clause and the church-state separation. What are we going to have now? Nobody really knows. So, moving on. This is a page that I really, really like. It has been updated since I first found it 5.5, 6 years ago, which is fantastic. The information on here is pretty accurate based on what I know and based on the research that I have done. So this is mgr.org. They have a bunch of information on this site about Opus Dei and religious organizations becoming too enmeshed in government, the impact that is having on American governance, particularly in regard to Opus Dei specifically. And we're going to be talking about Opus Dei and the reshaping of the U.S. Supreme Court, which I think is an important thing to talk about when we are talking about a Supreme Court that, managed to find a way to overturn landmark women's rights legislation, managed to find a way to throw out the number one quintessential test for the church-state separation establishment clause, and seem interested in entertaining cases that further kind of chip away at that. So I think it's important to understand the influences that are in the Supreme Court. I know it would be nice to believe that these Supreme Court justices are making decisions in perfect accordance with the law and not letting conflicts of interest or ideological perspectives or religious convictions color the decisions that they make when being a justice and implementing, directing law and policy. But unfortunately, I really don't think that that's the case. That's not the world that we live in. So I'm not going to be reading this entire page. You can see here for the contents, it covers quite a bit of ground. It talks about Leonard Leo and the Federalist Society. It talks about Leonard Leo's personal ties with Opus Dei, how the Federalist Society is a pipeline for producing influential and conservative people in law. They talk about Antonin Scalia, who was the original faculty advisor to the Federalist Society, the special faculties of Leonard Leo, the success in the reshaping of the Supreme Court, Opus Dei, and financial support, and then a huge long list of references after the epilogue. So because I'm not going to be going over this entire page, if this is the first time you're seeing this website, go check it out. Linked in the source document down below. It's got some great information on there, and because they list their references, which I love, you can go and chase down where they're getting their facts and their figures from and run with that information, if you will. So we're just going to be jumping to the reshaping of the Supreme Court section. It's not terribly long. Read what they have to say. So this is a quote. In total, the Federalist Society has had ties to 7 Supreme Court justices who were confirmed to the court. Justices Antonin Scalia, Clarence Thomas, John Roberts, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. Leonard Leo and the Federalist Society played significant roles in the judicial selection processes for all 6 of the sitting conservative justices. The first one on the list, Clarence Thomas. Around 1991, Leonard Leo was asked by the Federalist Society to become its first employee, although he delayed the start date so that he could help his good friend, Clarence Thomas, through his contentious confirmation process for the Supreme Court. Despite accusations of sexual harassment hanging over him, Thomas won Senate confirmation by a slim margin. Then there's John Roberts. In 2005, the Federalist Society began openly advocating for John Roberts to be nominated to fill a vacant seat at the Supreme Court. They succeeded, and John Roberts was appointed to the Supreme Court in 2005. Samuel Alito. A few months later, in 2005, the Federalist Society's sway had grown so much that it torpedoed President George W. Bush's own preferred candidate for another vacant seat on the Supreme Court, Harriet Miers, a judge and close friend of the president who wasn't a member of the Federalist Society, and pressured him to nominate Samuel Alito, one of its members, in her place. They succeeded, and Samuel Alito was appointed to the Supreme Court in 2006. Then there's Brett Kavanaugh. After Justice Anthony Kennedy announced his retirement from the Supreme Court over the summer, Trump called Leo several times a day to ask questions and compare notes. And when Trump nominated Brett Kavanaugh to replace Kennedy, Leo took a sabbatical from his day job to advise the White House and coordinate efforts outside on behalf of the nominee. Leo was present at the White House ceremony when Trump announced Kavanaugh's nomination. Then Amy Coney Barrett. Leonard Leo is the man who put Amy Barrett on President Trump's list for the Supreme Court. According to this quoted citation, the Federalist Society played a key role in her 2020 nomination, and Justice Barrett got a standing ovation at the Federalist Society gala after her nomination. Politico claimed that Barrett was groomed as a potential Supreme Court justice by the Federalist Society members when she was studying law at Notre Dame. In summary, as reported by the Federalist Society, in addition to his work at the Society, Leonard has advised President Trump on judicial selection, assisted with the Gorsuch and Kavanaugh Supreme Court selection and confirmation process, and served as a member of the transition team. He also organized the outside coalition efforts in support of the Roberts and Alito U.S. Supreme Court confirmations. Also proudly displayed by the Opus Dei's Catholic Information Center, CIC, in Washington, D.C., quote, Leonard has assisted 2 presidential administrations on judicial selection as an outside advisor and participated in the Gorsuch, Kavanaugh, and Barrett Supreme Court selection and confirmation process, as well as the outside coalition efforts in support of the Roberts and Alito U.S. Supreme Court confirmations. So this is a series of facts which are allegedly, apparently, proudly displayed by the Opus Dei Catholic Information Center, CIC, in Washington, D.C., and it's worth remembering that Leonard Leo is a frequent visitor at the CIC, as is Kevin Roberts, who is the current president of the Heritage Foundation, and we cannot overemphasize the role that the Heritage Foundation has had to play in shaping the political discourse in this country and in creating the set of circumstances that we all are currently existing in here in this country with this administration. So, some selected mentions in the press. In 2018, before the nomination of Amy Barrett in 2020, Leonard Leo can take credit for installing 4 Supreme Court justices. At that point, he had John Roberts, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh. Quote, an executive vice president of the Federalist Society, Leo has been the quiet architect of a pivotal shift to the right throughout the federal judiciary, including dozens of lower court federal judges across the country. So there is no overemphasizing the impact that Leo has had as well in shaping the political and legislative landscape here in this country. It was Leo who prepared Trump's list of judges and the people that he's put on the bench. A Washington Post analyst found analysis found Leo and his allies raised $250 million between 2014 and 2017 from undisclosed donors, and a chunk of that money has gone directly to campaigns to drum up support for judicial confirmations. As a presidential candidate in 2016, Trump promised that his nominees would all be picked by the Federalist Society. Yet, according to a person with direct knowledge of the situation, the list of Supreme Court nominees that Trump drew from in creating a conservative supermajority was advised by Leo alone. So this is a great page. If you are not familiar with it, please take some time to look at it. I'll scroll down and show you. Here's all their lists, their references, all hyperlinked with the HTTPS web link as well, so you can go through and fact check them on everything that is on this page. I mean, they're citing from the Federalist Society as well, and definitely think that what is on this page is worth reading if you are not familiar already. So moving on, this is a Church State article from 2021, so it is a little bit older, but I want to read it just because it's about Leonard Leo, Opus Dei, and the Catholic supermajority that we now have on the Supreme Court, which is a really important part of this entire thing. It's pretty much like the part that you need to understand if you want to understand the court cases and the decisions that have been made and the reasons why the Supreme Court is doing the things that it's doing, such as throwing out landmark legislation or tests like the Lemon test. It's very, very important. So I'm going to read through this. Some of you have probably already seen it. I have cited from this article in the past. What Leonard Leo wants you to know about Leonard Leo, first and foremost, is that he is a Knight of Malta. The Sovereign Military Order of Malta, SMOM, is a lay Catholic order that claims descent from the Knights Hospitaller founded in Jerusalem in 1099 at the end of the First Crusade. It's an extremely selective group. Of the 1.2 billion Catholics in the world, only 13,000 are Knights of Malta, although most of them don't go around bragging about it. Leo, I'm told, is very proud of this honor. First, because it demonstrates just how radically Catholic his radical Catholicism runs, and second, because it speaks to his importance. SMOM membership is the sort of status symbol that eluded him growing up in the middle-class suburbs of New Jersey, where his high school classmates derisively nicknamed him Moneybags. His mother and stepfather weren't blue bloods. He wasn't some wealthy boarding school kid. Poor guy had to make do with Cornell instead of Harvard or Yale. He was a nobody. But my, how the times have changed. Look at him now. Leonard Leo, 56, has made himself one of the most powerful figures in the United States. He put five justices on the Supreme Court: Amy Coney Barrett, Brett Kavanaugh, Neil Gorsuch, Sam Alito, and John Roberts. A sixth, Clarence Thomas, is one of his closest friends. And perhaps most impressively, he quietly led the 2016 crusade to deny Merrick Garland a hearing when Barack Obama nominated the highly regarded jurist to replace the late Antonin Scalia, another of Leo's pals. In the lower courts, he's been even busier. He's installed so many judges on so many courts, it makes you wonder if he really is the instrument of God's will he believes himself to be. I mean, there are only three branches of government. One of those three, arguably the most important one, is Leonard Leo's domain. You wouldn't know it to look at him. Leonard Leo is a short, foppish, pear-shaped man in wire-rimmed glasses and pricey suits. Think a dandier George Costanza, or if the Penguin worked at Jones Day. As Jeffrey Toobin wrote in the 2017 New Yorker profile that is now framed in Leo's office, quote, Leo is at ease in the role of impresario. His grandfather was a vice president of Brooks Brothers, the groceries? Brooks Brothers? And he instilled in young Leonard a taste for the bella figura. Leo wears tailored suits, often with contrasting waistcoats and a double-length gold fob attached to a 1935 train conductor's pocket watch, the most accurate watch in the United States until the 50s, he said. In lieu of office meetings, Leo prefers to chat over breakfasts, just bacon, no eggs, at the Hay Adams Hotel across from the White House. As his friend Boyden Gray, the White House counsel under George H.W. Bush, puts it, quote, he knows the best restaurants in every major city in the world and the best wines. He has a wide-ranging, inquiring mind, and he can and will talk about any subject under the sun." End quote. A gold fob, a fucking pocket watch. Several times in the article, we are told what an oenophile Leo is, a wine connoisseur ne plus ultra. I'm told he has his own little room in the wine cellar at Morton's. The steakhouse's best vintages aren't good enough for his refined Rothschildian palate. One assumes that he shares with the Paul Giamatti character in Sideways a near homicidal contempt for Merlot. Reading Toobin's profile, which again Leo was so proud of he had framed in his office, the guy strikes me as a pretentious bore, socially and intellectually insecure, desperate for people to find him extraordinary. And while I may be biased, I'm not the only one who shares this opinion. A former senior executive at one of the many entities Leo controls once remarked, quote, "Leo always thinks he's the smartest person in the room. He very rarely is." End quote. Ouch. That tracks. The smartest person in the room wouldn't be so inflexible in his adherence to the holy trinity of fundamentalist Catholic political dogma: no birth control, no LGBTQ rights, no choice. The smartest person in the room would question why the church advocating for these retrograde policies is the same one that provided cover for nests of serial pedophiles for centuries. The smartest person in the room would wonder if inveterate child molester apologists possess the requisite moral standing to denounce gays, lesbians, and trans individuals, or to force teenage rape victims to carry their fetuses to term. Although Toobin's New York profile was widely considered a valentine, or more colorfully, a blowjob, a puff piece, basically, the subject of said profile is clearly not the smartest person in the room. According to Leo, the vast majority of abortions are a consequence of voluntary consensual sexual encounters, an opinion that influences his view of the procedure. Quote, "We can have a debate about abortion," he told me. "It's a very simple one for me. It's an act of force. It's a threat to human life. It's just that simple." In the light of Leo's perspective, the possibility that he would put forward a Supreme Court nominee who would turn out to support abortion rights seems non-existent. Roberts and Alito have voted against reproductive rights, so in all likelihood will Gorsuch. And this is obviously an article written from before Roe v. Wade was overturned. We clearly know how all of this has played out. But just to keep getting through the article here, where to begin? The smartest person in the room would know that in the debate about abortion, such as it is, the only act of force involves the state forcing a woman to see through a pregnancy that she does not want, one that may have been begun against her will. Pro-life is a euphemism for pro-patriarchal authoritarian. The threat to human life, meanwhile, is the threat to the life of the mother that is inherently posed by any pregnancy. The smartest person in the room would grasp that a staunchly anti-choice government would put women in constant danger, at risk even of death, every time they have intercourse. The smartest person in the room would not think voluntary consensual sexual encounters comprised a heinous sin because he happened to read that in Deuteronomy or Leviticus. The smartest person in the room would understand that a woman's right to choose allows for individual morality. It couldn't be simpler. If Leonard Leo does not wish to have an abortion, Leonard Leo is free not to do so. And I will say that living in a post-Roe country now, a lot of these things have happened. Women have sickened and died. Women have been denied medical care that they desperately needed. Women have been apprehended and incarcerated for having something like a miscarriage, and the state in which that miscarriage occurred, viewing that as tantamount to murder. Basically, it's honestly gotten really, really insane, and it's heartbreaking because clearly this entire thing, the overturning of Roe v. Wade, was all about, allegedly, it was all about saving lives. But in reality, it's honestly having the opposite impact and will continue to do so. And innocent people women, and children are going to suffer as a result of this policy. And Leonard Leo has had a huge role to play in it. And he's not someone who is ever going to have to deal with the fallout, the negative consequences of the role that he's had to play in overturning landmark women's rights legislation. And they're not going to stop with abortion. FYI. If you think that, you're a fool. Alas, Leo is not the smartest person in the room, to the detriment of all American women. The strain of radical Catholicism practiced by Leo and his ilk bears little resemblance to the Catholic Church in my own New Jersey hometown where I was confirmed, or the one I encountered among the joyful Jesuits at Georgetown University where I went to school. As I understand it, the Church is about helping those less fortunate. That's supposed to be the primary focus. Plenty of Catholic charities and plenty of good Catholics understand this and behave accordingly. I fail to understand how the less fortunate are helped by encouraging discrimination against the LGBT community, which for most of America's history has been marginalized, harassed, picked on, beaten up, and sometimes executed, or by railing against the use of condoms, which prevent the spread of HIV, or by publicly shaming the pregnant teenager as she makes her terrified way to Planned Parenthood. As I see it, those things are self-evidently loathsome. But Leo is a dour, zero-sum faith, pure and flexible, unswerving. Less Inquisition, less lowercase I Inquisition, more uppercase I Inquisition. And this is no act. He really believes this crap. When I asked if Leo's faith was severe, Tom Carter, who was communications director at USCIRF from 2009 to 12, when Leo was the de facto chief, told me, quote, he believes he's on a mission from God. That mission is to mold the judicial branch to his liking, and in so doing, do away with Roe and protections for the LGBT community, and I also believe to further carry out an onslaught against civil liberties in this country. Let's just call it what it is. Understand, there are plenty of American Catholics who are pro-choice and pro-LGBTQ rights. President Biden, to name one, Justice Sonia Sotomayor, to name another. But Leo doesn't just want any old Catholic on the high court. If so, he would have been jumping for joy about Sotomayor's selection. Yes, at the moment, incredibly, 7 of the 9 SCOTUS justices are Catholic. What Leo wants are radical Catholics, the Church's answer to evangelical Christians, Jabad Lubavitch Jews, and fundamentalist Muslims. Because this strain of radical Catholicism lacks a proper name, it is harder for non-Catholics to make the distinction. This also makes it easy for its critics to be accused of being prejudiced against Catholics, just as critics of Israeli Prime Minister Bibi Netanyahu, a crook, are routinely denounced by his apologists as anti-Semites. And boy, has that conversation gone down the tube here recently. William Donahue, a longtime president of the Catholic League, wrote a letter to the editor of the New York Times in 2019 accusing Carl Hulse, that paper's chief Washington correspondent, of anti-Catholic bias for daring to suggest on a panel with another journalist that there is a real Catholic underground that is influencing the court in an outsized way. As if Leonard Leo didn't exist, as if the names of Donahue's board of directors were not all in the guy's Rolodex. Although 2% of the population is Jewish, Donahue added, and a third of the High Court is Jewish, no one ever complains about having too many Jews on the Supreme Court. The obvious difference is that the too many Jews on the court are not beholden to an obdurate religious doctrine that, if applied the Leonard Leo way, would compel them to oppose choice and LGBTQ rights. Indeed, the main reason Leo wants these judges on the court, as he makes no bones about, is because of this opposition. This is Leo's jihad. He wants to foist his extremist religious beliefs on all of us, to annihilate the firewall between church and state, to impose a medieval legal system that mirrors his radical Catholic faith. Call it Maria law. I should add here that Leo's view of Islam seems to be more 11th century than 21st. In the wake of 9/11, the U.S. Commission on International Religious Freedom, the aforementioned USCIRF, a federal agency that was controlled by Leo, led the opposition to the Ground Zero Mosque, despite this opposition being in direct conflict with its mission. A key organizer of the rally against the mosque, incidentally, was GOP fundraising maven and insurrection enthusiast Virginia Ginny Lamp Thomas, Clarence's wife. Around that same time, USCIRF was the subject of an EEOC complaint. Safia Gori Ahmad, an attorney with a graduate degree in international development whom the agency passed over, subsequently filed a lawsuit charging anti-Muslim discrimination. As the Daily Beast reported in 2017, in early 2010, after Gori Ahmad's original complaint was filed, staff and former commissioners told the Washington Post that organizers were rife behind the scenes with ideology and tribalism, with commissioners focusing on pet projects that are often based on their own religious background. In particular, staffers said an anti-Muslim bias runs through the commission's work, charges Leo denied. After winding its way through the courts for years, the court case ended in a settlement that people with inside knowledge have described as very favorable to Gori Ahmad, per Mother Jones. Even the mighty Leonard Leo takes it on the chin sometimes. So how does he do it? How does he wield so much power? Networking. Like an invasive cancer, Leonard Leo has metastasized from the Federalist Society to the broader conservative legal community. He now knows anyone and everyone from John Roberts to Mick Mulvaney to Ed Whelan to Seamus Hassan to Nina Shea to the sommelier at Morton's who pours out the vino. Despite being a generation younger, he was good friends with the late Antonin Scalia and remains tight with Clarence Thomas. Perhaps Leo, whose dad died when he was 5, regards these powerful men as father figures. He delights in pulling the marionette strings. He likes to place people, Carter told me. But it's the financial networking that moves the needle. Leo sits like a giant spider at the center of a complicated web of nonprofits and PACs and 501 whatevers. The Federalist Society, which identifies, develops, and grooms future conservative judges. The Judicial Crisis Network, the PR arm of the operation. The Beckett Fund, a legal outfit that does pro bono work for religious freedom cases. The Freedom and Opportunity Fund, which helped bankroll the Brett Kavanaugh nomination hoo-ha. Reclaim New York, a charity Leo set up in 2013 with Rebecca Mercer and Steve Bannon, the Council for National Policy, the Christian Coalition Group, and God knows how many others. For nonprofits, these entities sure do rake in the cash. Leo's association with Mercer and Bannon has been a veritable gold mine. As the Washington Post reported in 2019, between 2014 and 2017 alone, they collected more than $250 million in such donations, sometimes known as dark money, according to a Post analyst of the most recent tax filings available. The money was used in part to support conservative policies and judges through advertising and through funding for groups whose executives appeared as television pundits. The groups in Leo's network often work in concert and are linked to Leo and one another by finances, shared board members, phone numbers, addresses, back office support, and other operational details, according to tax filings, incorporation records, and other documents and interviews. There is $250 million in dark money donations, an almost unfathomable pile of cash. More than a little of that dark money wound up in Leo's pocket. At the time of the Brett Kavanaugh nominating process, Leonard Leo reportedly paid off the mortgage on his own home in McLean, Virginia, and also scooped up a $3.3 million luxury estate on the Maine coast. Like Jesus would do. He paid almost $1 million less than the appraised value of the home, which was sold to him by the estate of the late CEO of the chemical company W.R. Grace, J. Peter Grace, who is a fellow Knight of Malta. The rest of that vast pool of dough sloshes around from one dark money org to the next, where it can best be deployed. Leo plants op-eds in newspapers, and he buys ads, and he hires PR outfits to do marketing campaigns, and he lobbies, and he does it in such a way that no one can see the radical Catholic Oz behind the curtain with his gold fob and his decanter of Chateau Lafite. But what if Leonard Leo isn't the eminence Greece that he thinks he is? What if he is the one being played? So at this point in the article, they start talking about Opus Dei, calling to mind the Da Vinci Code novel and the film. They talk about, along with former and Attorney General Bill Barr, Leonard Leo served on the board of the Catholic Information Center, the Opus Dei stronghold on K Street in Washington, a few blocks from the White House. As such, he must have been influenced by the former head of that same Catholic Information Center, Father C. John McCloskey, an Opus Dei priest. McCloskey was single-handedly responsible for recruiting a number of powerful Washington insiders to, well, if not Opus Dei proper, then something decidedly un-American. This is from a piece Charles P. Pierce wrote for the Boston Globe in 2003 about a group he termed the Crusaders. Quote, there is a glow to the priest when he talks. He is talking about a futuristic essay he wrote that rosily describes the aftermath of a relatively bloodless civil war that resulted in a Catholic Church purified of all dissent and the religious dismemberment of the United States of America. There's two questions there, says the Reverend C. John McCloskey III, smiling. One is, do I think it would be better that way? No. Do I think it's possible? Do I think it's possible for someone who believes in the sanctity of marriage, the sanctity of life, the sanctity of family over a period of time to choose to survive with people who think it's okay to kill women and children, or for, quote, homosexual couples to exist and be recognized? No, I don't think that's possible, he says. I don't know how it's going to work itself out, but I know it's not possible, and my hope and prayer is that it does not end in violence. But unfortunately, in the past, these types of things have tended to end this way. If American Catholics feel that's troubling, let them. I don't feel it's troubling at all. And he's really giving Lord Farquaad, some of you may die, but that is a sacrifice I'm willing to make, in that quote there. Absolute madness. Per Newsweek, those in the McCloskey circle at that time included Leo's chums, Antonin Scalia and Clarence Thomas, Thomas's wife, Ginny Thomas, Louis Freeh, the shady former FBI director, the late conservative columnist Robert Novak, Sam Brownback, the hapless former governor of Kansas, Lawrence Kudlow, Trump's former economic advisor, Robert Hansen, the FBI officer who was a KGB double agent, and Bill Barr. Leo was in his 30s when Pierce wrote that article, a Beltway neophyte, but he was already on the varsity team. In addition to the surviving members of the McCloskey group, his current circle of devout Catholics include SCOTUS Justices John Roberts, Sam Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, former White House counsel Pat Cipollone, former Trump Homeland Security Attorney Ken Cuccinelli, Robert Severino, who, while director of the HHS Office of Civil Rights, authored some despicably anti-LGBTQ policies, Roger's wife, Carrie Severino, head of the Judicial Crisis Network and Leo's most trusted lieutenant, Mick Mulvaney, former White House Chief of Staff, Don McGahn, former White House counsel who stayed on the job as long as he did to facilitate the appointment of Leo-approved judges, George Conway and Kellyanne Conway. Let me be clear. My first inclination when I see the words Opus Dei and a list of notables is to dismiss the whole thing as conspiracy theory poppycock. I don't know how many of these people are actually members of that prelature, and it really doesn't matter. Call it what you like, but those individuals really are all connected and really were influenced by the hateful authoritarian thinking of Father McCloskey. Read those names again. Whether this is Opus Dei proper or something less formal, that is a fantastic amount of power concentrated in a very small circle of like-minded people. And I myself have spoken at length about the role that I believe, in my opinion, Opus Dei facilitates here in the United States, and the fact that it functions essentially as a conduit to connect like-minded people. And I agree with the author of this article. At the end of the day, whether someone is in fact a card-carrying member of Opus Dei matters far less than what their ideologies, convictions, and beliefs are, because if they are aligned with Opus Dei, they're aligned with Opus Dei, and that's really all that matters. Whatever eschatological hocus pocus McCloskey may have subjected these individuals to, none of them seem like exemplary human beings to me, including McCloskey himself. The priest was removed from his position at the Catholic Information Center when he was accused of sexual misconduct by a woman involved with the center. Not the first time he was booted out of a plum job. Opus Dei paid almost $1 million to settle the case and insists that the former priestly power broker now suffers from advanced Alzheimer's and has not had any pastoral assignments for a number of years and is no longer able to celebrate Mass even privately. The point is, the moral leader of Leonard Leo's little group is a handsy man of the cloth who cost Opus Dei $977,000 because he couldn't keep his mitts off a parishioner and who in the aftermath of the scandal wound up banished from public life. Leo and his pals are proponents of what Bill Barr in his controversial 2019 speech at Notre Dame called the traditional moral order, which is a euphemism for hatred of the LGBTQ community, atheists, agnostics, Muslims, immigrants, and women. But is it a moral order, though? A moral order that tolerates pedophilia? What's really going on here? Radical Catholics hate two things above all else: abortion and homosexuality. Morality debates aside, to staunchly and categorically oppose either one is to deny reality. If abortion is criminalized, abortions will still take place. Let me change this sentence and read it to reflect the current state of affairs. With abortion criminalized, abortions are still taking place in back alleys, illegally, by fly-by-night abortionists who only work for cash. Likewise, the criminalization of gay and lesbian sex will not stop gays and lesbians from hooking up. It will just drive the liaisons underground. And maybe, just maybe, that's the real objective. Before Roe, abortions were one of the many illicit services offered by crime syndicates. The mob took a cut of the fee and, more importantly, knew who was getting secret abortions and who the fathers were. The abortion racket, in other words, was a means to collect both money and dirt. Sodomy, to use the grotesque legal term, has been decriminalized for 2 generations, but men having secret rendezvous with other men is still used as compromat. Off the top of my head, I can name 3 current Republican senators, a former Republican governor, a former Democratic governor, and the businessman father of a member of Trump's inner circle who are rumored to dabble covertly in gay sex. How much more power would a potential blackmailer have over these people if man-on-man action was expressly illegal? And who, you ask, collects dirt on prominent individuals for the purpose of coercion and blackmail? Creatures of the underworld, crooks running rackets, and spooks working assets. Take a look at the McCloskey list again. There are so many spies. Bill Barr, the son of an OSS agent, was himself in the CIA and behaves like an asset for a former intelligence service. Robert Hansen, whose brother-in-law was Barr's speechwriter, worked for the KGB. Louis Freeh, head of the FBI when Hansen was busted, has connections to foreign intelligence services and is closely aligned with Rudy Giuliani, whose tentacles extend to Turkey, Romania, and Ukraine. Robert Novak deliberately outed a CIA agent. Not everyone is involved in espionage, of course, but there are a lot of foreign intelligence activity going on among members of Father McCloskey's original group, and that doesn't even count the Vatican, which boasts one of the oldest intelligence services going. Certainly, their activities were and remain shrouded in secrecy. If Opus Dei operated out in the open, after all, a crappy novel like The Da Vinci Code would not have sold so many copies. 2 more names to consider here. Steve Bannon, a Catholic who, 1, worked with Leo in the Reclaim New York charity, and 2, teamed up with radical Catholics to take on reformist Pope Francis, and 3, tried to set up a neo-fascist gladiator school in Rome, has ties to Chinese intelligence. And while there is no clear connection between Leonard Leo and mercenary CEO and Trump ally Eric Prince with his alleged ties to Emirati, Israeli, and Chinese intelligence, both of these enormously powerful and influential men are radical Catholics. Could it be that the push to criminalize abortion and homosexuality is intended to make the job of the foreign intelligence services easier? Could it be that the hardline views of true believers like Leonard Leo and his Torquemada besties are being manipulated to advance that agenda? Could it be that spies are exploiting the fact that a desperately insecure, status-conscious, nouveau-riche sycophant who is emphatically not the smartest person in the room believes that he is? It's an interesting hypothesis for sure, but let's take them at their word. McCloskey spoke of a relatively bloodless civil war because it's not possible for people like him to peacefully coexist with the LGBTQ community. Barr seeks a traditional moral order. Leo, as Jay Michelson succinctly explains in The Daily Beast, believes that most of the New Deal and administrative states are unconstitutional, that corporations have free speech and free religion rights, that women and LGBT people are not protected classes under constitutional law, and that there is no right to privacy implied by the Due Process Clause of the Constitution, i.e. banning abortion, contraception, and gay marriage, are entirely constitutional. Well, at least they were when this article was written. These are men who abhor the Equality Act, which passed the House yesterday. So that's mostly the meat and taters of the article. I wanted to bring your attention to all of these connections and how they have impacted the Supreme Court. This is not the only article on the subject, though, that I am going to be reading to you. The next one is from Politico, and this deals with the public school aspect directly. So I want to bring this to your attention. This was published back in 2024. I remember when it was published. I released a couple of posts summarizing different parts of this article on Bet Griffin and the Deep Dive Project on Instagram. It's an interesting article, and if you haven't read it all the way through, you should. The headline reads, Public Christian Schools, Leonard Leo's Allies Advancing New Cause. A tight-knit group of activists tied to Leo's nonprofit network are rallying around an Oklahoma effort to create a public Catholic school. So at issue was the Roman Catholic Archdiocese of Oklahoma's push to create the St. Isidore of Seville Catholic Virtual School, which would have been the nation's first religious school entirely funded by taxpayers. The school received preliminary approval from the state's charter board in June, and if it survived legal challenges, it would have opened the door for state legislatures across the country to direct taxpayer funding to the creation of Christian or other sectarian schools. So this was a big deal. This was a really, really incredibly important case that they were bringing forward and what they were trying to do. And I really do think that they thought that they were going to be an automatic shoe-in because of who currently sits on the Supreme Court. Brett Farley, executive director of the Catholic Conference of Oklahoma, acknowledges that the public funding of St. Isidore is at odds with over 150 years of Supreme Court decisions. He said that the justices have misunderstood Thomas Jefferson's intent when he said that there should be a wall separating church and state, but that the current conservative-dominated court seems prepared to change course. They were doing this at this point in time for this exact reason, because of that conservative-dominated court. Quote, Jefferson didn't mean that the government shouldn't be giving public benefits to religious communities towards a common goal, he said. The court rightly over the last decade or so has been saying, no, look, we've got this wrong, and we're going to right the ship here. So I have no doubt that Brett Farley is very well aware of the 2022 Supreme Court decision to toss out the lemon test, and that he and others were interpreting that toss as a sign that the Supreme Court would be friendly towards something like a taxpayer-funded religious school. Behind the effort to change the law are Christian conservative groups and legal teams who, over the past decade, have been beneficiaries of the billion-dollar network of nonprofits largely built by Leo, the Federalist Society co-chairman. Now, we did already read about a lot of that in the last article, so I'm going to skim through here so as not to keep repeating the same information over and over again. But they say in Oklahoma, the legal team representing the state's virtual charter school board, the Alliance Defending Freedom, helped develop arguments that led to the end of Roe v. Wade. It is significantly funded by donor-advised funds that allow their patrons to keep their identities secret, but which receive large amounts of money from Leo-aligned groups. It's been referred to as a dark money ATM. We're talking about millions of dollars being shuffled around, billions of dollars here. They say that since 2022, when Leo received a $1.6 billion windfall from Chicago electronics magnate bear seed, among the largest contributions to a political advocacy group in history. Other groups funded by Leo's networks have become substantial contributors to the Alliance Defending Freedom, ADF. For instance, Schwab Charitable Fund, which has given at least $4 million to ADF, received $153 million in 2021 from new Leo-aligned nonprofit that received the seed funding. So, like the previous article said, these various groups, entities, organizations help move all of this money around to the places that it needs to be. And for what it's worth, from my perspective, in my opinion, Opus Dei employs a very similar strategy with its various corporate works that it has, which it claims and swears up and down they have no connection with and no vested interest in. And these corporate works are just the efforts of people who happen to be members of Opus Dei, but they're not actually involved with directing how these members of Opus Dei are utilizing these corporate works. That's all up to them. I think that that's a load of bullshit. A lot of people think that it's a load of bullshit, and the reason is just because it very clearly seems to follow the same sort of playbook, with these entities serving as places to send or pool money, funds for the various efforts that Opus Dei gets engaged in. So, St. Isidore is represented by the Notre Dame Religious Liberty Initiative, a legal clinic created by the law school at the University of Notre Dame. And at Notre Dame, law professor Nicole Stell Garnett has worked with St. Isidore from the start of its application process. And she would ultimately, her connection to Justice Amy Coney Barrett would ultimately become the straw that breaks the camel's back for this case, which did not end up being successful because of that conflict of interest. So in that same time frame, Garnett joined the board of the Federalist Society, where Leo is co-chairman. She also joined the advisory council of a Catholic University Law School initiative funded by a $4.25 million anonymous gift directed by Leo, according to a March 2021 press release. Justice Samuel Alito was its honorary chairman at that point. The clinic itself was announced a few months before the confirmation of Barrett, who was a Notre Dame law professor for 15 years. The June 2020 announcement of the clinic's creation stated that Barclay would take a leave of absence to clerk for Gorsuch during the same time period, 21 to 22, and that the group was working with the Oklahoma Archdiocese on its St. Isidore application. In June of 2022, the court also overturned Roe. A month later, the clinic funded a trip for Justice Alito to be feted at a gala in Rome. So the impression that I am gaining from the information presented in these paragraphs is of a very enmeshed, very incestuous system that is being manipulated and mobilized to achieve very specific goals that are in line with conservative Catholic religious ideology. Clinic spokeswoman Kate Monaghan Connolly declined to say if Barclay has done any work on behalf of St. Isidore, including before, during, or after her clerkship. Notre Dame's clinic said Leo and some of the better-known nonprofits aligned with him have not given money to the clinic, declining to reveal its funding sources beyond a website link. In December of 2021, the clinic announced it was adding Brendan Wilson, a nonprofit and corporate tax attorney whose clients have included religiously affiliated schools, to its legal team. So they were building this team of people, getting everyone together, and getting ready to move on a case that, again, I think they were very confident would be successful because of who's on the Supreme Court. Those backing the St. Isidore application faced a formidable array of critics and opponents. Charter schools are required by Oklahoma statute to be non-sectarian, and in its application, the Archdiocese says the school would be part of the evangelizing mission of the church. The Oklahoma Attorney General Gentner Drummond, a Republican, says the proposed school violates both the U.S. and state constitution, and he sued to stop it. Separately, a group of 10 plaintiffs, including public school parents and faith leaders represented by groups including Americans for Separation of Church and State, filed a lawsuit warning that the creation of the school will erode a pillar of American democracy, the wall of separation between church and state. So it did end up going to court. The Oklahoma Supreme Court ended up seeing it. And I have some articles talking specifically about that, but I want to scroll through this Politico and make sure there's not any other last points that I want to make sure that I hit on. If you have not read this article in its entirety, please do go through and do so. It's got some just fantastic information, not directly pertaining to this church-state situation. So it says that Leo spokesman Adam Kennedy declined to comment, but they say that throughout his career building his nonprofit network, Leo has remained rigorously behind the scenes, rarely taking on a public role. But there's some quotes from him here where he says, "No question, Catholicism faces vile and immoral current-day barbarians, secularists, and bigots." Nice language to use for people who don't agree with your perspective. It can't be a difference of opinion. It can't be anything constitutional. It's got to be a matter of barbarians, secularists, and bigots. Okay, cool. These barbarians can be known by their signs, he says. They vandalized and burned our churches after the Supreme Court overturned Roe v. Wade, Leo said at a 2022 John Paul II New Evangelization Awards ceremony. He was the one receiving the award, FYI. From coast to coast, they are conducting a coordinated and large-scale campaign to drive us from the communities they want to dominate. Every accusation is an admission. But there's reason for hope, Leo said. Amongst the politically active, there is a marked increase in Catholic identity. That includes a growing number of Catholic commentators in the secular media, greater opposition to government efforts to regulate Catholic schools, and significant opposition to same-sex marriage. Of course, what he's not admitting here is that he is in large part responsible for all of that, but I digress. Like Catholic University in Washington, Notre Dame has been a prime focus of his attention. While the clinic said in its statement that it has not taken money from a couple of Leo's primary nonprofits, Leo has indirectly and directly contributed to the university's projects. Leo sits on the board of the Napa Institute Support Foundation, which has steadily increased its gifts to the university from $37,500 in 2019 to $150,000 in 2022. Leo joined the board in 2018. In 2021, he personally donated to an effort by the Napa Institute to establish programs on priestly formation and a lecture series at Notre Dame that hosted Justice Thomas as its first speaker. The personal connections to St. Isidore's legal teams extend to the court's conservative justices, including Thomas and Barrett. And what I want to very quickly remind everyone of, or bring your attention to if you are not aware, this Napa Institute and the Napa Institute Support Foundation are both entities that are connected to a very wealthy philanthropist and former real estate lawyer, Timothy Bush. And I have spoken about Timothy Bush's role to play in the conservative Catholic political landscape and discourse and everything that we are seeing in the video that I did about Opus Dei and Project 2025. So if you haven't seen that, you should go and check it out. But this is another Opus Dei thread that is running through this entire situation with this Catholic public school, because there are Opus Dei people present in both the Napa Institute Support Foundation and the Napa Institute, through and through. So they do talk about the conflict of interest here that Barrett had with Garnett, who is apparently Barrett's also a godmother of one of Garnett's daughters. So this goes beyond just being like a professional relationship or like workplace friendship. This is obviously personal for all of these people. Like I said, it's so enmeshed and incestuous how closely connected and personal all of these relationships between all of these people are. In recent years, the court's conservative majority has increasingly sided with religious plaintiffs, marking a reversal from its past enforcement of strict boundaries between religious and public life. Across the Warren, Burger, and Rehnquist courts, spanning about 50 years of court decisions, the religious side typically consisted of religious minorities, such as Jehovah's Witnesses, or Orthodox Jews alleging discrimination. They prevailed about half of the time, with gradually increasing success, according to University of Southern California professor Lee Epstein, who studies win rates before the court. So we have this slant becoming more conservative, becoming more religiously conservative, and we're seeing court cases like this Oklahoma School Board v. Drummond being brought forward to a Supreme Court that seems to be becoming more and more and more supportive of religiously motivated court cases. Regardless of how the initiative started, its advocates speak openly that St. Isidore is a national model. And this is why, even though St. Isidore's has been rendered dead in the water because of the Supreme Court decision, I do not think that this is the end of the story for these people or for the whole concept of a public taxpayer-funded religious school, or for just more broadly doing away with the church-state separation. This is only the beginning. Quote, more states ought to follow Oklahoma's lead, Richard Garnett said in a story touting the effort featured on the law school's website earlier this year. The school's champions include Oklahoma Superintendent Ryan Walters, who has endorsed holding a minute of silence for prayer in public schools and requiring a framed copy of the Ten Commandments in classrooms. He's posted a series of similar videos attacking President Joe Biden's woke agenda, transgender students, and critical race theory. It is incredibly important that churches are given the freedom to grow, he said in a video last summer. It was churches that started the first schools in the country. Yeah, but they were Reformation schools, a lot of them, for Indigenous First Peoples children. And the legacy of those schools is not good. While conservatives are eager to embrace St. Isidore as a legal test case, liberals are equally wary given the conservative makeup of the Supreme Court. Quote, schools are the last bastion of church-state separation, and they have been the target of Christian nationalists and the shadow network for decades, said Andrew Seidel, author of American Crusade, How the Supreme Court is Weaponizing Religious Freedom, who is part of the lawsuit by Americans for separation of church and state. That's why it's so striking. In 2022, they got a change in the personnel on the courts, thanks to Leo. So with all of that context, I know that this is getting long. Thank you for sticking with me. I'll try to move things forward because I think we're getting through the really important context of it all. This is just a very complicated situation that takes a little bit of time to get through to establish all of the parameters for and everything. So thank you for sticking with me. So this is an article. I have two of them pulled up just because I thought they were interesting. Published, this one was in 2023, and this was published on that Notre Dame Religious Liberty Clinic like website, basically, for the University of Notre Dame. So this is like the clinic that was bringing this court case forward. This is an article that they have published on their site. It says Catholic educators stand against religious discrimination before the Oklahoma Supreme Court, and it's talking about how they went to the Oklahoma Supreme Court to defend their right to help serve the educational needs of all families across the state. And that was the Oklahoma School Board v. Drummond case that initially got this whole thing started when the Oklahoma Attorney General Gentner Drummond decided to sue the effort to try to shut it down on grounds that it was unconstitutional, violated the church-state separation. It says St. Isidore seeks to defend its fundamental right to contribute to the diverse array of educational options made available to families through Oklahoma's charter school program. St. Isidore's filing stands against Drummond's insistence that the state may ignore St. Isidore's religious liberty rights and deny the school's freedom to take part in that program merely because it is religious. These lawsuits are baseless, they said, and distract from St. Isidore's mission of educating children. We are confident that the courts will recognize that, and I hope the suits will be dismissed quickly so that St. Isidore can focus on its work that is so important to families in Oklahoma. Because it always comes back to the work, doesn't it? It's always about the work, whether that is the Opus Dei work or just the staunchly conservative, alt-right, Catholic conservative work. This next article doesn't have a date, but it's just talking about this court case, the St. Isidore of Seville Virtual School v. Drummond case. They're saying that they're trying to provide much needed opportunity. They were trying to present this as being just like a boon to the community and not something that should be viewed as problematic in any way, shape, or form. It says in October 2023, they were sued for welcoming this partnership with faith-based educators. Drummond's lawsuit asked the Oklahoma Supreme Court to deny these critical educational opportunities solely because St. Isidore is faith-based. The Oklahoma Supreme Court heard oral arguments in the case and then granted the Attorney General's request condoning unconstitutional discrimination against religious educators and the children they serve. In January 2025, the U.S. Supreme Court granted St. Isidore's petition for review of the state court's decision. Following briefing on the merits, the U.S. Supreme Court heard argument on April 30th, 2025. So when this little blurb was published, the Religious Liberty Clinic at the University of Notre Dame, Leonard Leo, Opus Dei, and everyone else were still feeling very positive about the expected outcome of this court case. And if you're interested, they have all the court documents here linked on this page, so you can download these and have a look through them if you would like to for some reason. You can learn more about their work, and then they have further media and everything, and then some more information about a related case with another virtual charter board in the Oklahoma City. So they were feeling really, really good. And in May of 2025, the Supreme Court was considering eroding the separation of church and state and public schools as it considered the decision that they were going to make in this School Board v. Drummond case. And so this article is published on Medill News Service, May 2nd, 2025. It says, after the state of Oklahoma contested the right of a Catholic organization to get state funding for a charter school, the Supreme Court is weighing whether the separation of church and state required by the Constitution justifies Oklahoma's decision to keep charter schools secular. The court heard arguments Wednesday in Oklahoma statewide charter school board v. Drummond, and its decision, expected late June, could open the gates that separate the secular American education system from religion. The Archdiocese of Oklahoma City and Diocese of Tulsa in January 2023 contracted with a statewide charter school board to create the St. Isidore of Seville Catholic Virtual School. Just happened. Just totally casually, just some people unpertaining to anything else happening in the country or with government or the Supreme Court or anything else. They just wanted to get together to put this public Catholic school together. The Archdiocese, the school never began its classes as State Attorney General Drummond sued the statewide virtual charter school board. Of course, it went to the Oklahoma Supreme Court, and they argued with Drummond that charter schools as public entities could not use public funds for religious education. So the Oklahoma Supreme Court sided with Drummond that St. Isidore's, what they were trying to do, the way that they were trying to access funding was unconstitutional. In the wake of the Supreme Court's decision, the school board and St. Isidore of Seville Catholic Virtual School appealed to the U.S. Supreme Court. They said charter schools are private entities participating in a state program, and that preventing religious charter schools from accessing public funds is discrimination on the basis of religion. So they brought it all the way up to the Supreme Court. And I remember when all of this was happening back last year over the summer, I saw, these articles talking about how this case was being brought to the Supreme Court. And then I waited to see what I would hear next. And then I never heard anything. which I thought was really, really strange. And that made me wonder what had actually happened. Because something that I have noticed with these types of efforts, we'll just say, is that if the effort is successful, if whatever was being tackled or attacked is successfully won, then there will be articles all over the place crowing about the success of the venture. You know, very perfect example, case in point in the not too distant past was the overturning of Roe v. Wade. Couldn't hit a rock, couldn't throw a rock without hitting an article talking about the overturning of Roe v. Wade, for better or for worse. And then with this situation, we had articles all the way leading up, you know, from the Religious Liberty Clinic, from people associated with St. Isidore's, talking about how they were going to appeal this thing, how it was going to be this success, how they weren't trying to do anything untoward or unconstitutional, blah, blah, blah. And then, you know, we know it got all the way up to the Supreme Court, and then there were crickets. And I went looking to try to find an article talking about like what had happened. And, you know, we got articles in here from like, we've got Politico, we've got Church and State. I mean, whether or not you like those sites, they are like pretty popular, well-read sites. And I didn't see any following coverage from them on this situation. And so I did some Googling, and I found some interesting articles. So this article here, this was published May 22nd. The decision was still being considered, but it says that the U.S. Supreme Court split on the 4-4 decision. SCOTUS tie ends Oklahoma plan to open nation's first publicly funded Catholic charter school. This was carried by the Oklahoma Voice. So this is not a national news site. This is more of a state, local site. And one of the few sites that I could find actually talking about what happened with this court decision, what the actual outcome was, because it wasn't successful. And I don't think that any of the people who were talking a big game up to this point, talking about how this was going to be a success and everything else, wanted to then have to come out and say that they'd actually had their asses handed to them, screwed the pooch, missed a massive conflict of interest in their entire organizational structure, and were sent back to Oklahoma with their tails between their legs. So, a deadlocked U.S. Supreme Court has upheld an Oklahoma ruling that struck down the nation's first religious charter school. That's right. After several years of seeing articles and quotes and people talking about this thing, finally got all the way up to the Supreme Court. They had their big one. They were going to shoot their shot. And they shot and they missed. The court announced Thursday it voted 4-4 with Justice Amy Coney Barrett recused. The tied vote affirmed last year's Oklahoma Supreme Court decision that the concept of a publicly funded Catholic charter school is unconstitutional. They appealed the case. Oklahoma Supreme Court, U.S. Supreme Court agreed to take it up. Attorneys representing St. Isidore and the statewide board contend charter schools are not truly public schools, but rather private entities contracting with a state who therefore should be free to adopt a religion. Excluding faith-based groups from charter school funding is religious discrimination, they said. In light of the court's decision, St. Isidore's board of directors said it will continue exploring other options to deliver a virtual Catholic education for all in Oklahoma. So remember how I've been saying this entire time that things are not over and they're not giving up, and this is not the end of the fight by any way, shape, or form. Well, here you go. Here's the proof in the pudding. The board of directors for St. Isidore said they will continue exploring other options. They'll find a hole. They'll make one if they have to. Quote, families across the state of Oklahoma deserve the educational opportunities presented by St. Isidore of Seville Catholic Virtual School, the board stated. We are disappointed that the Oklahoma State Supreme Court's decision was upheld in a 4-4 decision without explanation. While the Attorney General led the legal fight against the school, other Republican leaders in the state, including Governor Kevin Stitt, advocated for giving religious groups access to charter school funds. Stitt said the matter is far from a settled issue. So this is not over in any way, shape, or form. The court's deadlock could impact a separate lawsuit challenging St. Isidore in Oklahoma County District Court. That case has been on hold while the Supreme Court appeal was ongoing. Oklahoma City Archdiocese officials said students of all backgrounds and beliefs would have been welcome at St. Isidore. Well, of course, I'm sure they weren't going to just discriminate people for any and all reasons. But once you're in that environment, what is the expectation? That's kind of the whole problem. The problem is not that a religious institution is only going to permit in certain people, although that would be discriminatory and that would be a problem. But I think at issue here is not whether or not they would have allowed people of diverse backgrounds to enroll their children, but what the expectation would then become for those children. Would their diverse faiths and beliefs be respected, or would they be expected to conform? I can tell you what my opinion and my belief is, and it is that they would be expected to conform. Americans United is discussing next steps for the Oklahoma County case with the plaintiffs and co-counsel. A religious charter school would be an abject violation of religious freedom, said Rachel Laser, president and CEO of Americans United. The Supreme Court's stalemate safeguards public education and upholds the separation of church and state. Charter schools are public schools that must be secular and serve all students. So this is the article that talks about why Amy Coney Barrett may have had to sit out that huge decision and why it all resulted in a split. And it's because of her close relationship with at least one of the people on this this legal clinic, the law professor Nicole Garnett, who, beyond just having had a professional relationship with that previous article that we read, also stated that there's a personal relationship there because she is one of her children's godmothers. So conflict of interest out the wazoo. The U.S. Supreme Court's ruling in the case packed the potential to expand the scope of religious institutions' access to public funding nationwide, and instead it ended in that 4-4 split. A total of 164 cases decided by the High Court from 1925 to 2015 ended in a tied ruling. In addition to recusals, the court has decided cases with 8 members following the death of a justice. The High Court's decision was announced in a brief 1-page opinion on Thursday. Quote, "The judgment is affirmed by an equally divided court. Justice Barrett took no part in the consideration or decision of these cases." End quote. The opinion does not reveal how each justice voted. So the decision invalidates prior approval of St. Isidore by Oklahoma's charter board. The lack of a national precedent allows religious schools to seek consent from state charter boards in the future, which could lead to further litigation. And I believe that we've not seen the end of this in any way, shape, or form. And I have good reason to believe that because of the migration that the St. Isidore board made over to a new Catholic virtual school, the St. Carlos Acutis Virtual Academy. This is another article from Oklahoma Voice. Again, one of the only sites that I could find talking about the fallout after this Supreme Court decision and kind of what has happened since everyone was sent back to Oklahoma packing. So shout out to Oklahoma Voice for keeping a finger on the pulse of this situation. They write, after their pursuit of taxpayer school funding failed to get approval from the U.S. Supreme Court, Oklahoma Catholic leaders have canceled plans to open St. Isidore of Seville, the Catholic virtual school, and will open a private online academy instead. The Archdiocese of Oklahoma City and the Diocese of Tulsa announced Monday the opening of St. Carlos Acutis Classical Academy in the 2026-27 school year. Named for a recently canonized millennial saint, the tuition-based virtual school will enroll up to 300 students nationwide in kindergarten through 8th grade before adding a freshman class the following year. Meanwhile, the website for St. Isidore of Seville Virtual School, named for the patron saint of the internet, is no longer reachable. Archdiocese of Oklahoma City spokesperson John Hesley confirmed that plans to open St. Isidore have been discontinued. A member of St. Isidore's board of directors, Brett Farley, also verified the school will no longer open. Brett Farley doesn't have so much to say now, does he? He was very chatty about how misguided and incorrect the founding fathers were in establishing that church-state separation. Are you incorrect, or are you just misguided? Catholic leaders will not seek state dollars for St. Carlos Acutis Classical Academy beyond a tax credit that assists private school students with tuition and fees, Farley and Hesley said. The Academy's website shows St. Carlos Acutis will have these same governing board members who sat on St. Isidore's board of directors, including Farley and other archdiocese officials. They're just shuffling to a new direction, guys. The new school will also fulfill a primary goal intended for St. Isidore, which was to make Catholic schooling available to students in all parts of the state. Listen, that's fine. That's fine to do if you want to create a school that a state can take advantage, not a state, but the residents of a state can take advantage of, or even the residents of a country can take advantage of. But what is not okay is when you are demanding that the residents of a state or a country who do not share your beliefs and perspectives give you their money so that you can propagate those beliefs and perspectives in public society. That is prejudicial to good order in law. That is not something that has ever been permitted up to this point in this country, and it would not be a good thing if that went the way of the dodo bird. One of the things we established through St. Isidore was that there is a definite need to reach every corner of our state for good quality Catholic education. And so Carlos Acutis was one of the things that we decided we needed to go with this. We need to actually provide this to the Catholic families and to really anybody who's interested in it. That is fine. I don't think that anyone is disputing their right to do that if they want to do that. That's fine. We have religious liberty in this country. You can have a school with religious underpinnings, religious motivations. We already have them here in this country. That is not a problem. The problem is the church-state issue and the fact that the state represents a diverse group of people, the American public, who do not all view the world through the same lens as these people like Farley and Leonard Leo and everybody else, and even the justices sitting on the Supreme Court. That is the sticking issue in all of this, and not something that can be distracted by or forgotten by any other issue. We need to keep that as like the focal point and the primary like subject here. Smith said the new academy will be a better and different experience than what students might have had at St. Isidore. Unlike the original virtual school concept, St. Carlos Acutis will have a classical school curriculum, a method of education often focusing on liberal arts, classic literature, and philosophy or theology. Teachers will give live instruction online, and students will have opportunities for hands-on learning, Smith said. The school's focus will be nurturing the Christian development of each student and providing guidelines for academic excellence within the context of the Catholic faith, the Archdiocese has said. Again, no problems there. No problems with any of that. The fight to open St. Isidore of Seville as the nation's first religious charter school started in 2023 with an application to the Oklahoma statewide virtual charter school board that was approved, but then obviously the AG sued, and that went to the Oklahoma Supreme Court. Oklahoma Supreme Court sided with the AG. Case got bounced up to the U.S. Supreme Court. They heard oral arguments beginning in October, and then the entire thing was dead in the water when Justice Amy Coney Barrett had to recuse herself. The new virtual academy will bear the name of the Catholic Church's first millennial saint, born 1991. His life exemplified humility, piety, devotion, and discipline, blah, blah, blah. Very nice, very nice. Again, I have no problems and no bones to pick with people of a religious perspective wanting to have a religious educational institution. I don't have anything bad to say about that, but like I said earlier, that isn't really the issue at play here. The issue is the fact that they wanted to use US taxpayer dollars to get this thing off the ground and running, and that is simply unconstitutional. It is just unconstitutional given how things currently sit with our liberties and our Constitution and our policy and our legislation and everything that makes this country what it is from a governmental legislative perspective. It just doesn't work. So I wanted to talk about this situation and bring it to your attention because, like I said, I think there's probably a really good chance that you missed this unless you're just somebody who likes to follow this kind of news. I think that this is a significant situation because, again, like I said, it's a sign of the times. It's a sign of where the conversation is heading in this country, or at the very least, where a very influential block of people would like to take the conversation. And I wanted to take some time to talk about this, take you through some of the articles. Hopefully you have learned something new from this whole spiel, and hopefully I've created a desire in you to look into this a little bit more, or some other aspect that we discussed in this video. Again, do not take everything here as the one-stop shop source of information about anything that I discuss. Please take what I have said and run with it. Do your own research. Get involved, especially if you are an American citizen and if you have children who are going to be entering the educational landscape in this country. It's not a perfect landscape by any means. It's got a lot of problems. We have a lot of issues that we need to address. American literacy is a huge problem, and these are conversations that are important conversations to be a part of, especially if you are someone who either you or a loved one could be impacted by this entire thing and how it is shifting and changing and everything. So thank you for giving me your time and attention for this subject today. I sincerely appreciate it. I'm looking forward to hearing any thoughts that you have in the comments down below. Did you know about this? Were you following it? Did you know that they were not successful? What are your thoughts on the whole St. Carlos Acutis virtual academy that is now being spearheaded by these exact same people? Do you agree that there is something kind of untoward going on here? Or do you think that like everything is on the up and up and this is all perfectly normal and right and just? I'm interested in hearing what you think. Interested in hearing your thoughts. So please do let me know down below. Details to connect with me across social media, support my ventures, all of that are linked down in the description below. If you or someone that you know is dealing with mental health struggles, I also have a variety of resources in the description down below that are global. I went all over the web and tried to pull resources from different regions and different countries just to put something together so that if you are struggling or if you know someone who is, you can go down there. Maybe there's something there that if it isn't directly applicable to you, it can at least get you started in the right direction, get you started looking for some answers and for some help, because life is incredibly difficult, and bullshit like this, people like Leonard Leo, they don't help. They are not helping, and it's really, really difficult, but we don't have to go through life totally alone or unequipped. There are resources that you can take advantage of and people who really do want to help. So if you need help, please reach out. With all that said, please like and subscribe if you have not already. Consider sharing this with someone that you know, and I will be back for another video in the not too distant future. In the meantime, remember, nolite te bastardes carborundorum. Don't let the bastards drag you down.